Good afternoon, everyone. We'll wait a couple of minutes to allow everyone to enter. Thank you for joining us today for the Path Forward, exploring the impact of the Supreme Court's decision on affirmative action. As you see in the chat, live captioning has been enabled for this webinar. To view or hide the captions, click on the closed caption or CC button in the Zoom navigation bar. Today's webinar is being hosted and sponsored by Temple University's Center for Anti-Racism, its Beasley School of Law, and its Office for Undergraduate Admissions. I am Valerie Harrison, and I serve as Vice President for Diversity, Equity, and Inclusion here at Temple. The other persons you see on the screen are members of our incredible tech support team, and also three of my esteemed colleagues who will participate in today's discussion. First, let me introduce you to Dr. Jose Aviles. Dr. Aviles is our Vice Provost for Enrollment Management. He is a national expert who brings decades of experience and expertise to this issue. Next, Dean Don Harris. Dean Harris holds both a JD and LLM degree, is a distinguished scholar, and serves in a number of roles at Temple's Beasley School of Law, including Associate Dean for Academic Affairs, Diversity, Equity, and Inclusion Liaison, and Professor of Law. And Professor Timothy Welbeck, an accomplished civil rights attorney, a professor, and director of Temple Center for Anti-Racism. In the next hour or so, we hope to explore the recent Supreme Court decision, Students for Fair Admissions versus Harvard, in a number of ways. First, we hope to provide you with a better understanding of the decision and its historical context and of affirmative action in higher ed. Second, we want to offer perspectives on the potential impact of the decision on future admissions policies and practices at Temple and also elsewhere. And third, our panel will share their perspectives on the broader implications of the decision for equality and social justice work. So let's get started. Professor Welbeck, the majority decision was written by Chief Justice John Roberts, who acknowledged that even after the passage of the 14th Amendment and the Equal Protection Clause, which granted citizenship to formerly enslaved persons and provided that all citizens are entitled to equal protection under the law, he said the Supreme Court, alongside the country, quickly failed to live up to the clause's core commitments. For almost a century after the Civil War, state-mandated segregation was the norm in many parts of the United States, and part of what he called an ignoble history. So talk to us about affirmative action. What is it? Tell us about its history in higher ed and from your perspective, whether it's necessary and important.
Thank you, Dr. Harrison, for that introduction and for that question itself. Affirmative action, the actual term itself, originates from the Wagner Act that allowed workers to unionize. President Kennedy is the first president to use the term as a reference point for racial equality and policies around that. At its core, affirmative action as it relates to higher ed was seeking to address that history that you just referenced, that for more than a century, every conceivable facet of life and society in America segregated on the basis of race. And particularly as it related to higher ed, many of these post-secondary institutions excluded Black people from joining them as students. And so as a consequence, affirmative action sought to find various forms to remedy that history and to conceive of policies to work around that. The first case that we commonly refer to as an affirmative action case is Bakke, Board of Regents of California versus Bakke. And effectively, the University of California at the time had a quota system for their medical school. And of the 100 spaces that they had, they allotted them 16 of those spaces for qualified minorities. Baki applied to University of California, among other schools. He was denied admission. He felt as though he was qualified and was overlooked because of his race. And so he sued. The case goes to the Supreme Court, and the Supreme Court upheld the constitutionality of affirmative action as a policy, but they did do away with what we call quota systems. You could not designate a specific number of people to set aside for admission, but they did say you could consider race as a factor. And so there are various cases along the decades that followed, but some of the more important ones next were Gratz v. Bollinger and Greta v. Bollinger, the University of Michigan cases. In those cases, we're looking at, again, what affirmative action policies were permissible. With the University of Michigan at the undergraduate level, they also had a point system. And this point system would allow for students to gain various points for different achievement, academic merit, and other types of things. Among those, they would give people points for being a racial minority or being from a geographically diverse region, things like that. The court upheld the ability of the University of Michigan, again, to consider race in their decision-making process, but they could not assign points to the consideration of race, which they were doing in their undergraduate system. And that was Gratz. Greta was its companion case, and it was looking at a similar practice at the law school where race was one of many factors that was considered. And so the Supreme Court upheld the ability to do that, but notably, one of the things that they did was they said that this will not always be in place. They said that this is not a permanent consideration or a permanent policy. And they also signaled that it would be narrowly tailored. And so for those of us who have a familiarity with the law, that basically means that this is one of the strictest standards that you could use. And then one of the more recent cases before the decision last week was was Fisher versus Abbey. The University of Texas has what they call the Texas 10 program. If you graduate in the top 10% of your high school class at a public school in Texas, you receive automatic admission to the University of Texas. The remaining about 25% of spaces, then they are doing traditional admission. And part of that process included race as a consideration. Abby Fisher was one of the people who applied to University of Texas, was denied admission. She felt as though she was qualified and was overlooked, and she challenged the constitutionality of it. That case upheld affirmative action, but many legal observers felt as though the death knell was coming, in part because the court has been eroding this process over time. But in some, though, affirmative action has just been a policy to give qualified applicants from marginalized communities an opportunity they were historically denied. And what we've seen over time is this policy has been eroded and it's been chipped away against, and sometimes we've lost sight of the original goal because of that. But ultimately, it was about giving qualified applicants who were historically denied an opportunity. And so now we are in this new terrain that the court has overturned that consideration as well.
Thank you so much. Let's stay in the law school classroom for a second, Professor Harris. And as Professor Welbeck mentioned, many believe that affirmative action is necessary to remedy the effects of hundreds of years of intentional and state-mandated disadvantage. And so the majority of the justices disagreed. Help us understand what the court means when it says that remedying societal discrimination does not constitute a compelling interest that justifies race-based state action.
Sure. Let me first thank you, Dr. Harrison, for hosting this and putting this together, and also for inviting me. The thought that you just raised right there relates to what Professor Welbeck just mentioned. As he well explained, the entire thrust of affirmative action programs was really to remedy the effects of centuries of discrimination. Yet in the case that he mentioned, Baki, the court rejected the University of Davis's justification of countering the effects of societal discrimination. And why did they do that? The court said that this idea of remedying societal discrimination and centuries of discrimination was an amorphous concept of injury, and that it might be ageless in its reach into the past. So what the court is saying is there might be some kind of injury here. We don't know what the injury is. We don't know how long it goes back. It's hard for us to justify affirmative action programs on that. It is really hard to overstate the effect of this particular ruling, denying justification based on remedial effects. Because what this does, at least in my view, it says it's not enough that the federal government discriminated for centuries, and it's not enough that states discriminated for centuries against Blacks and others. And it's not enough that the undeniable effect of this invidious discrimination is this extraordinary, deep-seated, and long-lasting problems of racial inequality that pervades all aspects of life. That's not enough. You cannot use that to justify affirmative action programs, even though that was the precise reason for such programs. The court did hold open one sliver, though, and it said that if you can show that this particular institution discriminated in this specific instance, then affirmative action policies are okay. But you can't rely on this idea of remedying centuries of discrimination or current societal discrimination. And so what happened is that the court, it really hobbled the movement even before it started. And so not only does this ignore centuries of injustice and oppression, but the result was that diversity became the only permissible goal that justified affirmative action programs. And again, from my view, not only was this extremely damaging, but what it does is it shifts from affirmative action's remedial posture to focus on this diversity aspect. And I think it moves the conversation from racism to race. And so we can talk about race, and we can't confront its shadow racism. And so, again, I think that this exacerbates tensions surrounding affirmative action. It's okay to say, in our opinions, let's consider race as one of many factors, at least before the recent decision. But we can't consider the long history of racism. We can't bring that into the conversation. And the harm from racism is long lasting. And so I think it was a mistake to move from let's talk about racism to let's talk about race. Let's not talk about remedial actions, and let's only talk about diversity. But that's where we were. And so from Bakke until last week before last, the recent case, we were focused on diversity as the compelling interest. And the only compelling interest to justify race as a factor in admissions. And now we're moving away from that. And so it feels to me that from the very beginning, we were fighting with one hand behind our back. And now we get yet another tool taken from our toolbox, which doesn't mean that the struggle or the fight's over. It just means it's going to be harder.
I agree. Thank you so much for that. And let's talk about tools. Let's move a little bit to the practical. Thank you for setting that up so wonderfully for us, both of you. The majority held that nothing prohibits universities from considering an applicant's discussion of how race affected the applicant's life, whether through discrimination or through inspiration, so long as that discussion is tied to a quality of character or a unique ability that a particular applicant can contribute to the university. So for example, a discussion of a student who overcame racial discrimination can be tied to the student's courage and determination, or a discussion of the student's heritage or culture may have motivated them to assume a leadership role or to attain a particular goal. Justice Roberts wrote, the student must be treated based on his or her experiences as an individual and not on the basis of race. Dr. Aviles, how does this impact Temple University specifically? And should we expect any changes in our admissions practices?
Well, thank you, Dr. Harrison, for setting this important conversation and setting it in motion. You know, for Temple specifically, in perhaps a positive way for us, you know, I deeply believe that and as Dr. Welbeck had laid out, this has been coming a long way coming in the work of college admissions and truly in selection. And many of us in the work who grew up in this work have kept close eye and our thumb on the pulse on each case as they have been debated at the court level over time. So here we are, and the reality is that I think that the work that needs to happen at this point in every environment for every institution is going to be more profound and perhaps require more resource, more effort, more intentionality to squarely focus on diverse communities. and to stop moving away from just doing the work of finding talent in the most common of places, well-resourced schools across the country, private and independent schools. Those schools are phenomenal, and we should spend time there. But if you look at some of the examples of what has happened at other environments, I'll take UC Berkeley as an example of an institution that has, over the last 3 years, increased their diversity without being able to use race. I'll note that despite spending millions of dollars over the last 30 years, Berkeley has not been able to replicate the diversity they used to have before the Bakke case. But over these last 3 years, they've done something that has been truly, I think, honorable in terms of, and really the outcomes are respectable in terms of growing diversity. And what they have decided to do very proudly and very clearly and vocally is to say, we're going to invest time and resource in diverse communities, and we're going to really go into these communities and start building pipelines to shape aspirations and shape exposure to a place like Berkeley. Well, Temple has been doing that. And that's why our classes, when you look at the work that has happened here at Temple, this year's class coming in is going to be the most diverse freshman class in our history, with more than half of I think it's 56% of all deposited students at this point are reporting they are of color. And that's phenomenal. That is a phenomenal, and it really bucks the trend for a lot of public institutions of our size and type across the country. But what has happened is that we have decided as an institution that we're going to spend time, starting right here in our backyard, to do the hard work of really shaping the pipeline. And oftentimes in admissions, that's one of the most costly things that you can do without a direct outcome, because typically to do this work well, you have to reach back into middle school and to really start working with families at a grassroots level. So I think this is a clarion call at this point for all institutions, especially the institutions across the country that are the most elite of all, to really take those rich resources they have and make those investments in these communities and start building pools that are much broader and more representative of American society. For Temple, what I love about Temple is that the work that has started here at Temple and has been done over time is just a foundation. For us, that means we have to double down our investment in resource, in effort, and time, starting right here in North Philadelphia and really digging into Philadelphia as a city and then radiating out. That's what I'm excited about from this decision. I try not to focus on things I don't control, right? And I knew that this was a coming decision over time. And so here we are. So let's roll up our sleeves and get to work.
I agree. And thank you. I'm excited about, the numbers aren't everything, but they are, it is good. It is a good measure of a lot of the work we've done for many years. And as you mentioned, the incoming class in 2023 will be 56% students of color. And last year, the fall of 2022, for the first time in Temple history, we did not have an ethnic majority in our incoming first-year undergraduate class. 51.3% of those students identify as a person of color. So when we drill down, the numbers tell a very positive story. 19.4% of our first-year undergraduate students in the fall of 2022 identify as African American, which is not insignificant, given that African Americans represent about 14% of the national population, about 11% of the state population. Hispanic or Latinx students represented 11.5% of our incoming class, and Asian students represented 15.6% of our incoming class. And so you've talked a little bit about rolling up our sleeves, getting to work. Are there any lessons or best practices that can be learned from institutions like Temple that have successfully maintained diversity?
Well, listen, this work, I mean, one of the things that, and I don't want to be too harsh in the criticism of the court, but what I will say is that, these decisions oftentimes want to remove the reality of where, inequity sits. And try to pretend that everything coming, out of the high school and educational environment in America is a level playing field. And I think in college admissions, one of the things that we have, if you're going to do this work successfully, you have to recognize first and foremost that to build a diverse class, it means that you're going to probably outwork most other admission offices if you're going to do this work well. And it's focused on relationship building, right? It's focused on relationship building. It's focused on shaping aspiration and really helping students get exposed to our environments, to show students, families, and communities that we truly can be an authentic destination that is ready-made for a diverse community. And by the way, I'll tell you that, for an enrollment environment and for a community like ours here at Temple, it's important to recognize that you cannot be a truly elite academic environment without being truly diverse. That's just a fact. And so for us to have the kind of rich environment that we have that makes us an elite learning environment for students and families across the country, this is essential for us. We have to find and dig in ways, broadly speaking, to maximally diversify this environment through multiple spectrums, not just race and ethnicity, but it starts with race and ethnicity. We cannot push that aside. And for us, it means that we are going to have to do more pipeline building programs at scale, which means that the good work that's happening across the institution that is serving 100 students there or 200 students there or 25 students there, can we bring that together and leverage the impact of that work to build a more intentional pipeline into our community here at Temple? We have to find ways in which we can spend more time in the community and in middle schools to help students start kind of looking at academic coursework and experiences that's going to challenge them and prepare them. And really, I would say also stimulate that ambition to want to learn and be part of an experience like what they're going to find at an R1 at Temple University. It really is not some one size fit all, and it's not something that you're going to just be able to generalize. I would also say it's not something that's transactional. A postcard isn't going to do it. Going to a college fair isn't going to do it. This is the work of building relationships and honoring these communities that have so much talent, promise, and potential. And by the way, that this country needs to participate in higher education to keep our economy being the leading economy in the world. And that's the role of an institution like Temple University, situated right here in Philadelphia. And even when I say that, Dr. Harrison, that gives me goosebumps to think about that's the consequential work that we get to do every day on this campus for the city of Philadelphia and for this country.
I agree. I am going to ask Professor Harris to weigh in. As you know, in terms of these relationships, Temple has partnerships with many Philadelphia high schools. We have dual enrollment programs. We have academic enrichment programs. We have summer experiences for students so that we are creating the relationships and the pathways to Temple. That's for undergraduates. Professor Harris, could you weigh in on what you see as the impact of this decision on experiences and opportunities for graduate and professional school students? Does it differ, or does the same best practice apply in graduate and professional schools?
I think they apply equally in both settings. Obviously, undergrad enrollment is going to affect graduate enrollment. The fewer students that we see in undergrad means the fewer students that we're going to see in graduate programs. And we've seen the cascading effect in California, for example. So Dr. Aviles mentioned California and Berkeley, and as soon as California was no longer able to consider race in admissions, we saw a dramatic drop-off in students of color, particularly Black and Latino students. And we have not gotten back there with what we think of as race-neutral alternatives. And so I don't think that it's that the negative effects of this decision are speculative. We know what's going to happen. And I appreciate Dr. Aviles' positive outlook that we can get back to where we want without considering race. But in terms of your specific question about graduate programs, I think we're going to see fewer students, at least initially, and I hope that we get back to where we are, but we're going to see fewer students in graduate programs. I mean, I think that is going to be a fact. And what it means for those particular students means there's going to be more isolation. There's going to be more of a loss of a sense of belonging, fewer students with whom they can commiserate, perhaps some stigmatism. But I also think it means a loss for society in a way that we might not capture with simply looking at undergraduate. So if we're talking about the professions, for example, for which you need a graduate degree, well, we're going to have fewer folks in the professions. And there's I hear a lot of rhetoric, a lot of concern about displacing whites in the professions. And the facts just belie that notion. If we look currently just in my profession as lawyers, you see that white lawyers represent 76% of lawyers, 76%. And that's as of this year. If we look in terms of law professors, white law professors represent 67% of professors. Then even looking outside of the legal profession, if we think about Fortune 500 companies, the CEOs of Fortune 500 companies, we're not even talking about white folks, we're talking about white men, 88%. And so there's no displacement going on there. But if we don't have graduates, if we don't have students of color in graduate programs, then we're not going to get them in professions. And I think society in general is going to be harmed. We know from businesses, from law firms, from corporations, how they value diversity, how bringing this different perspective and experience to the table changes things. It gives you a better experience. It gives you better knowledge. It gives you better decision making. And so losing this, I think, is going to be significant. But as Dr. Beasley said, this is the hand that we're dealt. And so we're going to have to do things to ensure that we get back to a place where we are now. Because again, I don't think that there's any question that there is going to be a drop-off at the undergraduate level, a drop-off at the graduate level, because as good as race-neutral measures are, they simply are not a replacement for race-conscious measures. But Temple's prided itself on its inclusiveness and its diverse student body. And so this opinion just makes us have to go back to the drawing board and think real hard about how we can achieve that.
Thank you. And so in addition to, again, rolling up our sleeves and doing the work to create pathways, again, our relationships with our K through 12 partners, but also, we have relationships with HBCUs. Our med school does a lot of work in terms of creating pathways to medical school. There are scholarships available to those interested in law school as well for graduates of Lincoln and Cheney. And so there is work that we do around that to create pathways. The court also focused on sort of crafting essays. And so, Dr. Aviles, I'm going to ask you about this. What advice do you have for students and educators in terms of creating or crafting your essay in light of the decision?
Yeah, I think, again, the court has been helpful there in a small measure, because it gives us that avenue to consider how race has played a part in your lived experience, and what does that really mean. So in terms of a college admission office, in my work, I have always intended that the veil between our office as an admission office and the community is torn down, that we are present and our resources and truly are oriented with a heart to want to serve students to the best of our ability. And I think one of the things that we've done, this is Dr. Harrison's, my ninth institution that I have served in the work of college admissions. And often what I find is that we've created these processes that are so complex, so complicated and hard to navigate. You almost need, an instruction manual to try to navigate the things that we've created. And for what purpose? For what reason? Right. And for me, I think college admission offices fill that space, at least the staffs that I've been a part of and the work that they have done that I'm so inspired by. It's about, again, setting up shop in the community, helping students and families understand how to navigate the process. And I think that's where the essay comes in, is to provide that guidance directly to students at the point of application, to be very intentional and direct in terms of how they write and craft those statements, those essays, and to think about how race and their identity has played a role in their lived experience in ways that might have created both challenges and opportunities. That the framing of that essay and helping students think about it from that lens perhaps hasn't necessarily been something that has been thought about, but needs to be very intentionally placed centrally in the thought process of how you might write your essay to allow an admission environment, no matter if you're going to Temple or you're going to another environment, to consider that element of who you are, which is, again, allowable based on how the decision has come out.
That's great. That's great advice. Thank you so much. And affirmative action has been a topic of debate, for decades. And the majority opinion in this case, as well as the dissenting and concurring opinions, raise a number of issues that are part of this national conversation on affirmative action. And so I would appreciate your thoughts and reaction to some of the key arguments that were made. Professor Welbeck, I'll start with you. Justice Ketanji Brown Jackson, she focuses on gaps in income, in wealth, in health outcomes between Blacks and whites. And she concludes that today's gaps exist because freedom for Black people was denied far longer than it was ever afforded. She concludes that a university should be able to value what it takes for an applicant whose ancestors received no race-based advantages to nonetheless now make themselves competitive for admission to a selective university. Your thoughts on that?
I think Justice Ketanji Brown Jackson is precisely correct in her assessment of things. The United States has known slavery longer than it's known anything else in terms of the actual period of history. That period is the longest time of the United States history. The period of racialized segregation was nearly 100 years. And there are people who are still alive who are dealing with the impacts of that and the progeny of those various forms of policy. That is something this nation should consider. There were unique harm that were done to specific groups of people in this country based on their racial category. Black people were deemed to be property for 250 years. Black people were denied entry into every form of society, whether you're looking at housing, whether you're looking at medicine, whether you're looking at education. All of these various forms of society have racial impacts and racial disparities that are linked to this broader history. That is something that should be considered when we're looking at this, particularly if we're going to consider other ancillary factors. For example, Harvard is one of the named parties in this suit. Harvard's admissions policy considers a host of different factors. They consider your academic merit, they consider your recommendations, they consider whether you're related to someone who's been there before. We call that legacy. They will consider whether you're related to someone who's given a substantial amount of money to the university. They will consider whether you played a sport in high school. All of those things are considerations that they make, but particularly if we're looking at legacy, this is something that Justice Ketanji Brown Jackson considered. She said, if you look back 6 generations, and she used examples from people from the University of North Carolina, if you go back 6 generations for one family, that family is enslaved. If you go back 6 generations for another family, that's the beginning of that family's legacy at the University of North Carolina. That is absolutely something that the University of North Carolina should consider because it's having implications on the trajectory of the lives of the people who are applying to these various universities. And it's not just UNC, it's not just Harvard, it's all of these post-secondary institutions. One of the things that I've mentioned, I'm going to embarrass my sister for a moment, but my sister went to Princeton University for her that's where she received her undergraduate education. Princeton was founded in the 1700s. Princeton did not remove its racial barrier for admittance until 1942. That's the first time they regularly allowed for Black people to go to Princeton. Princeton did not have its first women students regularly until 1969. So for an applicant like my sister, who is a Black woman, we are one generation removed from the first opportunity that someone like her has an opportunity to go to an institution like Princeton. Those are absolutely things that these universities should be considering because we need unique remedies for the unique harm that was done. And that's actually what the majority said in the first affirmative action case, that consideration of race needs to be specific to understand that we have treated people differently. So we must treat people differently as we're doling out benefits because that's how we've operated previously. And so with that, we are fortunate that we have a justice like Justice Ketanji Brown Jackson, who was mindful of this history and who's willing to preserve a historical record, even if in dissent, so that we can completely have an understanding of the implications of a decision like this.
I agree. And you've talked about a couple of things, and so I'm going to pick up on a few of those, but I'm going to ask Dr. Aviles about Justice Sonia Sotomayor's her dissent as well. She emphasizes that because of achievement gaps that result from this entrenched racial inequity in K through 12, a heavy emphasis on grades and standardized test scores disproportionately disadvantages underrepresented racial minorities. You know, Dr. Aviles, many schools have moved to test optional alternatives and the like. Could you comment, and what is your reaction to Justice Sotomayor's statement?
I think she's right on. I think that there needs to be a clear understanding that, you know, across the country, the way that K-12 is situated and how it has evolved over time has naturally created an uneven, unequitable playing field. And generally and broadly speaking, environments that are well-resourced and other environments that are not so well-resourced. And that creates the differences that exist in how students come out of K-12 and then enter what some of us want to believe, and not me, but others might want to believe was a truly equitable process in education up to this point. But I'll also say to her point is that what we've learned over the last 40 years in the research around selection methodology is that the quantitative factors that squarely oftentimes are looked at from a test score or even just grades in high school, isolated alone, aren't the full scope, the full scale of one person's talent and ability, certainly not their promise and potential. So there has to be a broader way to assess students and to assess students based on their context, right? A student, I believe, especially for a public institution, and I've now spent my leadership life squarely centered on large public universities like Temple. This is my fourth. I believe that for an institution like Temple or large public R1s for their states or their regions, we really should be looking at students who have done the very best with what they have been given. It doesn't matter how well resourced your school has been or not, but if you're a valedictorian, if you're a salutatorian of your high school, you should have the opportunity to participate in that public flagship or public research one institution that is really going to be that leverage point for your life and your life's trajectory to go on and do amazing things in this world. Right. And so how do we really capture a student's talent has to be broader than just looking at grades alone. It has to be made in context of a significant amount of information, not just grades, tests, but also qualities that make you who you are that sometimes are hard to quantify. But we also know that, you know, that there's things that oftentimes post higher education, you see people that are outperforming others who didn't go to the best schools, perhaps in some scale, probably are grittier than others, more resilient than others, pushing through things or just working harder. And that working harder starts to be quantified over time as just excelling, right? You're out competing people that are sitting to your left or to your right. Those are things that we can identify through a selection process that's well considered, well thought out. So I think Justice Sotomayor is so on point with that.
And let me pick up on something that Professor Welbeck just said, Dr. Aviles, and ask you to comment on this. Justice Neil Gorsuch argues that both Harvard and UNC could obtain significant racial diversity just by reducing legacy preferences and increasing financial aid for socioeconomically disadvantaged applicants. He points out that athletes and children of donors and alumni and faculty members together make up less than 5% of applicants to Harvard, but they constitute 30% of applicants admitted each year. And so while race neutral on their face, his argument is that these preferences benefit white and wealthy applicants the most, yet Harvard continues to stand by them. Would like your reaction to that, and also following that, Tim, Professor Welbeck, yours as well. You mentioned it earlier. If I could just hear your thoughts on that.
Yeah, I'll just be quick on it. I think Dr. Harris was so right. This has been tested over and over and over time. After the Fisher case, I was at a former public university of the same size and scope as Temple, and we had a box over in the corner of my office with the test of all the race neutral methods that we could have employed, statistically based, modeled based, and there was just nothing that we could have done to really have the same level of diversity that we were achieving by having diversity identified at the point of application and considered as one of many factors in the way that we debated and deliberated before each and every candidate. So I don't think there's a simple, and we did look at legacy structures at that institution, and again, just was not enough. You have to be, if you're trying to solve a problem, you have to run at the problem. You have to solve the problem intentionally and not water down solutions by making things ambiguous and kind of, I think those are all just tactics to kind of move away from what people want to move away from. There's just no other way of doing it than being more intentional and direct about it.
Professor Welbeck.
I completely agree with Dr. Aviles as it relates to that. And in part for what I was mentioning earlier, there was a unique harm that was done that was targeted, and we need targeted solutions. And while removing legacy considerations might facilitate that process to some degree, it still is not still not a total solution. Again, with the example of my sister has nieces and a nephew. If we remove legacy admissions, they now don't have the benefit for this miracle that she was able to accomplish by making it to Princeton University. And so then we now have a double penalty for someone like my sister and her family, and that she was able to achieve the inconceivable, and then now she is being punished by that for what's supposed to be a corrective measure. And so we need an ability to target the centuries of exclusion of Black people in America, and we need to not be afraid to call it what it is too. And I think some of this conversation has been revolving around a timidness to talk about the actual problem itself and to deal with that there were specific harms done to specific people groups, and we need specific remedies in order to do that. And we need to give those remedies time to work. We can't give these remedies a fraction of the time of the harm and then expect them to undo all the harm that was done. So to that, I completely agree with what Dr. Aviles said.
I agree with you. And I want to, Professor Harris, I want to sort of stick with this theme a bit. Justice Clarence Thomas emphasized that universities may offer admissions preferences to students from disadvantaged backgrounds, and he said that they need not withhold those preferences from students who happen to be members of racial minorities. He went on to say that universities may not, however, assume that all members of certain racial minorities are disadvantaged. Would love to hear your thoughts on that.
Drs. Welbeck and Aviles get Justices Jackson and Sotomayor, and I get Justice Thomas.
Absolutely.
Yeah, Justice Thomas, I think, is uniquely challenging. Well, one comment before I get to that question, and that's the question that you just posed about not using legacies or donors or friends of schools.
Please do.
I think that there's an assumption there that if we don't give those to the disproportionately white applicants that we do right now, that they will then go to Black students or underrepresented students. There's no guarantee that that's going to happen. We can simply still give those places to white students. And so while I'm not advocating for or against legacies, preferences, white preferences, I'm simply saying that there's no automatic guarantee that they're going to be given to students of color. In response to Justice Clarence Thomas, I think what he's arguing there are two different things. So on the one hand, he's saying that we can look at socioeconomic status, and that can get us to where we want to be in terms of a diverse class. And so he's pitting class-based preferences or class-based affirmative action policies versus race-based affirmative action policies, and saying that they are the same, or that the result can be the same. And I just think that I just disagree with that. I think that there are things that come from race-based affirmative action policies that class-based affirmative action policies do not get to. And so for one, I'll say that again, I do not think that race-neutral policies have the same effectiveness or can be as adequate as race-based. And it goes to right to what Dr. Beasley and Dr. Wilbur talked about. You know, we have unique harms and we need unique solutions. Let's tackle the problem. Let's stop getting away from the problem and talk about the problem. And so again, I don't think that that class-based is going to substitute for race-based. And again, this isn't to say that we should not also look to class-based. I think it's this false choice that we have to do one or the other. I think that we should be doing both. And it's also, I might say something that might be controversial, but it's not that I'm against low-income white students getting in. Yes, we should, but I think that skin color makes a difference. And if the low-income status is not because of color, then I think that there's a difference there. I think that low-income status for Black people can be traced to color, can be traced to the fact that you're Black. And so let's address that. It also brings up an article I read about two giants in my view, and that's Justice Marshall and President Obama. Both of them were asked about this particular question, class versus race, and asked, do you think that your children should get any kind of advantage from affirmative action programs? And President Obama said, no, he did not think that his two daughters should, that he thought that any kind of advantage should go to low-income students. And Justice Marshall had a different view. Justice Marshall said, damn right, my students should benefit from it. And you know, I respect both their opinions. I think my opinion is probably closer to Justice Marshall's, that yes, because we're talking about race, we're not talking about income. The other thing that I think he's talking about, in addition to this class versus race, is stereotyping. And it comes through not only in his opinion, but also in Justice Roberts' opinion. And the idea is that if you're admitting students just because of their race, expecting that their race is going to be somehow representative of their experiences or their perspective, then you're stereotyping them. And they say, not all Blacks think alike, not all Blacks have the same experience. Well, that's undoubtedly true. Blacks do not have the same experience. But what I will say is that Blacks still have a different experience than whites. So it's undoubtedly true that Justice Thomas and I, both Black men, do not have the same experiences, the same values, the same views. I'd be hard pressed to find something that we agree on. But that doesn't mean that he and I don't have different views. And for example, Justices Alito, Gorsuch, Kavanaugh, just because we grew up as Black men in America. And I also think that this stereotyping, why is it only limited to race? Schools legitimately seek students from different geographies. So schools may want someone from Idaho, they may want someone from New York, and they should have them. But are we saying that all people from Idaho share the same perspectives, have the same views? Of course not. Are we saying all people from New York? No, we're not. But we are saying that people from New York might have a different perspective than people from Idaho. In the same way, if we talk about socioeconomic status, do all poor people think the same way? I mean, the stereotyping argument is really frustrating for me, because it's true that we don't all have the same experience, but we do have experiences, and some of those experiences, race is a powerful factor in some of those experiences and our perspectives. And so to say that we shouldn't consider race because it's stereotyping, I think just misses the point.
So now you see why I asked you the Clarence Thomas question. Thank you so much for that. All righty, I'm going to ask a final question for each one of you. And it's the same question. I'd like each one of you to weigh in on this. Do you think that there are broader implications in higher ed or outside of higher ed, sort of for employment, for supplier diversity, maybe even for faculty recruitment, because of this decision. And we'll just go in alphabetical order and start with you, Dr. Aviles.
Well, I definitely would want to hear the legal minds that we have on the panel. I really would hope not. I was scared leading up to the decision that this would be farther reaching, and that it would creep into those other spaces, especially in our world, things like positions that were assigned specifically to recruit or do work in communities related to more diverse reach into communities, and so I think there was a lot of conversation nationally about whether we would see a farther reaching decision. So I'm not the legal mind. I want to hear what the panelists want to say, and I would just hope to God that that's really not where this goes from here.
Professor Welbeck.
So I do believe,
And that's not alphabetical order, actually. I went to the wrong legal mind, huh? Yeah, right. Let's keep it alphabetical.
okay, I'm sorry.
Professor Harris, I'm sorry.
No, that's quite all right. I do not mind. I think that this is just the beginning, that we are going to have plenty of litigation about what the opinion allows schools to do and what it does not allow. I think there's some parts of the opinion that give some kind of hope, and Dr. Beasley talked about it earlier in terms of personal essays. You are able to use race or talk about race so long as it reflects on some other attribute that we can talk about, for example, overcoming adversity or some kind of character attribute. But I do worry that there will be people who interpret this much more broadly than just being limited to institutions of higher education and limited to admissions policy that consider race. So we might see it in the employment context, for example, where employers are using affirmative action policies to diversify their ranks. We might see the court saying that this, or courts saying that this opinion says that employers, you can no longer do that. Now, there are different bases, different statutory and constitutional bases. In the admissions cases, school admission cases, we're talking about 14th Amendment, and we're talking about Title VI. And in the employment context, we're talking about Title VII. And so this should not reach those decisions, but I can already hear arguments that yes, it does. I also think, just in terms of, we're just focusing on schools, there are lots of things that schools do that some people might think run afoul of the decision. So if we talk about outreach efforts, recruiting efforts, if we talk about financial aid, if we talk about diversity programs at the school, those might all be things that people say, this decision says you can't do any of those things. We just saw a couple of days ago, the Missouri Attorney General said that race-based scholarships are forbidden under this decision. Now, I don't read the decision that way. I don't think they said anything about race-based scholarship. They were talking specifically about admissions. But here we have Missouri Attorney General saying that no race-based scholarship are going to be permissible. And so again, how broadly are we going to read this decision, or how narrowly are we going to confine it just to its facts and just to what the court said? I think that remains to be seen. But I don't think that I'm being pessimistic in saying that I am positive that there will be litigation trying to stretch this decision further.
And Professor Welbeck.
I completely agree with Professor Harris. The opinion is, at least it's within its four corners of the document, limited to post-secondary admissions. But as Professor Harris said, we're already hearing arguments and threats of litigation to expand the scope of the decision. And he highlighted many of the arguments that we're hearing right now. And I think we're in a decades-long battle to look at undoing affirmative action at every conceivable level, because as I started in the beginning, it was something that began discussing around employment, and then it evolved into higher education. And so now we're seeing the circle reverse itself back to its origins. I think is a good speculation to see. And so I completely agree with Professor Harris. I think that that's what's on the horizon. And as Dr. Avila says, that means we have to roll up our sleeves and get to work.
I agree, and that is an excellent way to close. And thank you for the encouragement, and the charge again for us to continue to do the work, to create and to expand additional pathways to educational opportunities, and then to wrap resources around students to guarantee their success. And so that's the work that has been fundamental to our mission, and I think we have to double down on that. And so that is an excellent way to close. And with that, that's our time. I thank you, my colleagues and those in attendance, for your interest and for your participation today. Thanks to the other persons, again, that you see on the screen, our IT support team. We appreciate you more than you know. We have recorded this webinar and it will be posted on the university's website at diversity.temple.edu. Have a great day.
Thank you again.
Thank you, everyone.